Hello, my name is Sam Manfredi of Manfredi Levine, and this is one in a series of 2-minute legal updates for the real estate community. The question for today, what is a prescriptive easement? Let's start off with an example. Let's say you have two homes and they share one common driveway. The driveway belongs to one of the homes but not the other. Does the home who does not own the driveway have an easement over that driveway? Well, first you would look at the legal title of that home to see if there's an actual easement, an express easement in the title. If there's not, then there is no easement. They could possibly have a prescriptive easement, but that easement would have to be defined and taken to court. Let me explain. The elements of a prescriptive easement are open, notorious, hostile, and continuous for 5 years. So if they've been driving over it openly and it's been without the next door neighbor's permission and it's continuous for 5 years, then you might have the elements of an easement. You then would go to court, file a lawsuit, and prove to a judge that you're entitled to have an easement on that driveway. That could then be put into your legal title. In San Francisco, they have high-rises, and those high-rises in the business district sometimes have, right on the corners of the property, little brass plaques in the ground that say, "Permission to pass over, revocable at any time." Why do they do that? Because once that owner grants permission, he takes away one of the elements, which is hostile, and he prevents anyone from getting a prescriptive easement over the corners of his property. Folks, it's a really interesting area. There's lots of case law, but it's complicated. If you're buying a property and there's issues regarding fence lines, it doesn't matter whether there's bushes or sprinklers and it's been used for 20 years, you need to get to counsel. You might have prescriptive easements, you might not. Thanks for listening. We will see you next time.